So without further ado, I'm just going to get into it. This is my brief layout. So, sorry, just need to orientate myself a bit. Okay, so development is ingrained throughout human history and is an integral part of life, economic growth, and social well-being. And people have aspired to be better and improve their lives and build cities since the early ages. And big cities and urban agglomerations are a common sight in the modern world. Just as development is part of nature, so too is the dependence of humans on natural resources and the ecological services that they provide. All parts of nature, are intricately connected, and its existence is dependent on the balance between its elements and components, meaning that if one part is depleted or taken out of the equation, other parts will resultantly also be affected. And somewhere along the way, the lines have been blurred between using the natural resources sustainably and overexploiting such resources to the point where the natural capacity of the environment is decreased. In light of unabated urban development and rapid urbanization, cities and city environments face severe challenges that include, for instance, pollution and the resultant changes in city climate, also known as the urban heat island effect. Furthermore, the constrained capacity of ecosystem services and declining resources exacerbate circumstances and necessitates the protection of natural environments in cities. Increased protection of urban environments is necessary not only for curbing ecosystem degradation, but also for ensuring human health and well-being. Human well-being and the continued existence of natural resources are dependent on the ecosystem services that nature provides. So the objective of this presentation is to determine the adequacy of the South African environmental legal framework in providing for the protection of microclimate regulation as an urban ecosystem service in South Africa, given the challenges associated with urban environments. So ecosystem services are defined as the benefits that people obtain and use, either directly or indirectly, that are provided by nature through its naturally occurring processes and functions. These services sustain and fulfill human life and are considered actual life support functions. And according to the Millennium Ecosystem Assessment, these are the 4 categories in which ecosystem services are divided. And I think Melandri briefly touched on them in her presentation. So I'm only going to focus on regulating services, which are essential for the continuation and existence of ecosystems and the organisms therein, as these services regulate and attempt to balance the environment in which humans and other organisms need to live and survive. These can consist of a wide variety of services, such as water purification and retention, waste treatment, air quality maintenance, carbon sequestration, and obviously also microclimate regulation. And in the context of ecosystem services, microclimate regulation forms part of the regulating ecosystem services and can deliver services such as microclimate regulation and the moderation of extreme climates by decreasing the effects of urban temperatures on residents' health and well-being, alleviating urban heat island effects, and improving the thermal comfort in urban areas. Urban areas are, however, more susceptible to higher temperatures due to urbanization, deforestation, and the lack of natural counterbalances to eliminate or mitigate the heat in cities. Microclimates are present when the climatic conditions in a specific or smaller area are different than that from the areas around it. And urban microclimates, similarly, occur when the local climate observed in the city differs from that from the surrounding rural area. Microclimate regulation then occurs when objects in the environment, such as trees or wetlands and buildings, influence the climate of the particular space around it, forming a microclimate. Ecosystem services that provide microclimate regulation services are worthy of protection because they help to mitigate the heat island effect and anthropogenic heating caused in cities, which in turn improves the resilience of the city and decreases the negative impacts that heating has on the environment and ecosystems, as well as human health and well-being. And the way in which this protection can be ensured is through the law. Ecosystems and environmental protection receives legal recognition in the Constitution and the environmental legal framework. And South Africa boasts an extensive environmental legal framework that aims to realize the environmental rights set out in Section 24 of the Constitution. The environmental right forms part of the Bill of Rights, and according to Section 7.2, organs of state in all spheres of government must respect, protect, promote, and fulfill these rights. The environmental right is a substantive right and entails positive action to be taken by the state to protect the environment for the benefit of present and future generations by employing legislative measures in lieu of preventing pollution, as well as ecological degradation, meaning further that the state should refrain from transgressing on these rights through negative action. Section 41 of the Constitution goes further and states that different spheres of government are distinctive, interdependent, and interrelated, and sets out the principles of cooperative government. And it also contains the provision to the effect that organs of state in all spheres of government have the obligation to ensure and secure well-being of people of the Republic. When read together with the first subsection of the environmental right in Section 24, Section 41 highlights that the well-being of the constituents of the different spheres of government must be secured, and it can, under these circumstances, be considered as an enforcement of the environmental protection duty that falls on the organs of state. This duty may be achieved through securing and ensuring a safe and healthy environment that's not harmful to the constituents' well-being. The environmental right also speaks to sustainability, which has been touched on also throughout this conference, and that occurs in the NEMA principles. And with respect to the environmental protection also, the promotion of a safe and healthy environment, furthermore, forms part of the objects of local government specifically, and they must achieve these objects within their available capacity. If Section 152 is considered alongside Section 24, it might be argued that the object of local government is to promote social and economic development, and that this is closely intertwined with its object to promote a safe and healthy environment. Local government in particular also has specific developmental mandates in terms of Section 153. The Constitution also touches on development and planning in Schedules 4 and 5, which sets out functional areas of legislative competence. And even though the environment and nature conservation is listed as concurrent competences of national and provincial sphere of government, it is argued that these are in certain cases incidental to the legislative competences of local government. And due to their mandate in other legislation as well as the provisions of the Constitution, they may legislate on these matters to ensure a safe and healthy environment. The planning and developmental duties mandated to the different spheres of government also give rise to planning legislation such as SPLUMA. Too often, however, the environment and planning are considered to form part of two discrete and separate areas of governance, and yet they are inextricably connected to one another based on the notion of sustainable development. This brings me to the place of the environment and environmental protection in the South African legal framework. And ecosystem services find some resonance in the definitions of, or in the definition of the environment as provided for in Section 1 of NEMA. Ecosystem services are included in the form of cultural ecosystem services in the words aesthetic and cultural properties of the definition, provisioning services in the part that states that the environment is made up of land and water, which can assist in the provision of food and water, for instance. And it can also be argued that supporting and regulating services are included in this definition, as it mentions the interrelationships between land, water, and atmosphere, and microorganisms, plants, and animal life. I also want to briefly stand still at the principles set out in NEMA, and these principles speak specifically to the avoidance, minimization, and remediation, for example, of disturbance of ecosystem and loss of biological diversity, pollution and degradation of the environment, as well as waste. And it also speaks specifically to the use and exploitation of non-renewable natural resources in a way that is responsible and equitable. And it considers the consequences of the depletion of the resources and states that the development, use, and exploitation of renewable resources and the ecosystems of which they are part should not exceed the level beyond which their integrity is jeopardized. It also specifically reiterates that negative impacts on the environment and on people's environmental rights be anticipated and prevented, and specifically mentions sensitive, vulnerable, highly dynamic, and stressed ecosystems, such as, for instance, coastal shores, estuaries, or wetlands. And it's similar systems which require specific attention in management and planning procedures, especially where they are subject to significant human resource usage and development pressure. The NEMA also provides for instruments like environmental implementation and management plans, outlook reports, and other integrated environmental management frameworks, such as environmental frameworks, strategic assessments, impact assessment, risk assessments, management programs, norms and standards, and spatial development tools. Some of these instruments are also provided for in the sector-specific legislation, or the SEMAs. So NAMAQA for instance, provides that norms and standards may be set for ambient air quality and contains provisions regarding the emissions of certain gases, which enables ecosystem or environmental protection through prescribing standards to emissions. And holds that municipalities may also, in their bylaws, set local standards or identify or establish emission standards for certain sources. And the lowering and monitoring of emissions and pollution, especially in cities, can greatly contribute to lowering the urban heat in cities. NEMBA also allows for biodiversity planning and monitoring, municipal conservation plans, and bioregional and management plans, all of which have conservation and protection of South Africa's biodiversity at aim, and which includes plant species and vegetation that contributes to microclimate regulation. NEMICMA allows for the composition of coastal protection zones in order to improve the management to protect ecological integrity of coastal public property, and also allows for management plans, programs, planning schemes, and land use schemes of municipalities, and the drafting and implementation of bylaws. For coastal cities, this act can greatly assist in protecting coastal zones that may contribute to heat mitigation and the decrease of urban heating. NEMPA, interestingly enough, is the only act to make specific, explicit mention of ecological goods and services. And in terms of this act, protected areas may be established to protect highly sensitive, outstanding ecosystems, species, geological or physical features, and for purposes of conserving and protecting ecosystems. South Africa's natural systems or the ecological integrity, and to prevent exploitation or occupation inconsistent with the protection of the ecological integrity of an area. Some ecosystems close to cities or bigger urban agglomerations can contribute to fighting the urban heat island effect if they can be declared as protected areas and subsequently protected from development. Proper waste management in terms of NEMWA can also reduce carbon and other emissions that exacerbate urban heating. And the National Water Act aims to ensure that the nation's water resources are protected, used, and developed in ways which take into account meeting the basic needs of people and promoting equitable access to water, as well as promoting efficient, sustainable, and beneficial use of water to allow for the establishment of water management areas, as well as other measures to facilitate and improve water security, which Melandri touched on. This act touches, the Water Services Act touches on issues of water quality and basic needs of people in terms of water security and the provisions in South Africa. I quickly want to just also mention SPLUMA and the Municipal Systems Act. So SPLUMA sets out the planning system of South Africa, which consists of SDFs, which must be incorporated into the IDPs of municipalities as per the Municipal Systems Act, and development principles that include spatial sustainability, efficiency, spatial resilience, and good administration, as well as norms and standards. SPLUMA is also intended to guide the planning and development decisions of sectors of government and must ensure that sustainable development occurs, meaning that the environment as well as socioeconomic issues must be considered and that they must be balanced so that neither is compromised for the sake of the other. Municipal SDFs also must include strategic assessments of environmental pressures and opportunities and include locations of environmental sensitivities, further making provision for land use schemes, which may determine categories of land use zoning. Zoning in terms of land use schemes may also be made especially for conservation purposes, meaning that land declared for conservation may only be used for such purpose to ensure minimal impact on the environment. SPLUMA also contains provisions for bylaws in order to enforce land use schemes. Then I just want to quickly just mention a few city responses, as cities have attempted to address these issues experienced in cities such as biodiversity loss, ecosystem degradation, and urban heat island effect. And some examples include the JMOS and the DMOS, which are metropolitan open system areas developed by these by the Johannesburg and Durban, or eThekwini, metropolitan municipality, and aim to address lack of and depletion of open and green spaces in cities. The city of Johannesburg, for example, boasts a wide range of species and habitats, wetlands, grasslands, and also an urban forest, which can be seen in the picture in the slide. And the lack of proper planning can lead to degradation of these ecosystems and in turn contribute to the heat island and city temperatures increasing. Other plans such as bioregional plans and spatial planning tools can also aid in the protection of ecosystem services and ecological areas. And other initiatives by the city include, for instance, rehabilitation of wetlands, maintenance and upgrades, and tree and planting new park developments. I'm almost done. Just one more minute, sorry. In terms of COVID, In the onset of the COVID pandemic, there was significant reduction in emissions and pollution and also urban heat islands, as mentioned in other presentations also. And animals seemed to appear in areas where they're not usually seen due to development and urbanization, for instance. But what we see now is that things are reverting back to the relative normal, and that there is once again an increase in pollution and emissions as parts of the economy open up again and things return to normal. And we are setting forth bad habits from before the pandemic, even though it has shown us that we have the ability to reduce emissions and pollution. And these are some of the questions that come to light for me. So what have municipalities or governments done in terms of environmental protection in the time of COVID? And one issue which has been prevalent in South Africa, for instance, and which has been addressed in this conference, is lack of access to water services. But what about before that? Several of the South African provinces have been declared disaster risk areas due to severe drought experienced in these areas. And a national state of disaster was also declared. But in March, the minister didn't renew this state of disaster. And the question that really bothers me is, are municipalities and government departments doing enough with the tools at their disposal? Which brings me to my conclusion. As Melandri also said in her presentation, the instruments and law available will only be as adequate as its implementation. We have the legislation and even some policies which enable municipalities and other government departments and stakeholders to act on and enforce environmental protection and subsequently the protection of ecosystems and the services they provide, and also microclimate regulation, which can be read into these acts. And these are at the hands of or within the reach of municipalities and government, but it is how they will use these instruments that will be the determining factor. Thank you very much. I really appreciate the opportunity, and I will now stop screen sharing.